Justice Dinesh Maheshwari to declare his view.
With reference to the questions which we had formulated, and thereafter with reference to the submissions made by all the learned council, these are the three major issues, or rather three major points for determination formulation as to whether reservation is an instrument for inclusion of socially and educationally backward classes to the mainstream of society, and therefore reservation structured singularly on economic criteria violates the basic structure of the Constitution. B, as to whether the exclusion of classes covered under Articles 15.4, 15.5, and 16.4 from getting benefit of reservation as economically weaker sections violates the Equality Code and thereby the basic structure doctrine. C, as to whether reservation for economically weaker sections of citizens up to 10% in addition to the existing reservations results in addition of basic structure on account of reaching the ceiling limit of 50%. These points for determination have been dealt with reference to the relevant constitutional provisions, doctrine of basic structure and constitutional amendments. Thereafter, the segments of the judgments are expanding doctrine of equality, affirmative action by reservation, exception to the general rule of equality, economic disabilities and affirmative action, whether economic criteria as sole basis for affirmative action violates basic structure, EWS reservation not availing to certain classes, whether violates basic structure, breach of 50% ceiling of reservations and basic structure, and then there are other factors and summations. After having dealt with these aspects, the conclusions are as follows. For what has been discussed and held here in above, the points formulated in paragraph 31, I just read that, are answered as follows. Reservation is an instrument of affirmative action by the state so as to ensure all-inclusive march towards the goals of an egalitarian society while counteracting inequalities. It is an instrument not only for inclusion of socially and educationally backward classes to the mainstream of society, but also for inclusion of any class or section so disadvantaged as to be answering the description of a weaker section. In this background, reservation structured singularly on economic criteria does not violate any essential feature of the Constitution of India and does not cause any damage to the basic structure of the Constitution of India. B, exclusion of the classes covered by Articles 15.4, 15.5, and 16.4 from getting the benefit of reservation as economically weaker sections, being in the nature of balancing the requirements of non-discrimination and compensatory discrimination, does not violate Equality Code and does not in any manner cause damage to the basic structure of the Constitution of India. C, reservation for economically weaker sections of citizens up to 10% in addition to the existing reservations does not result in violation of any essential feature of the Constitution of India and does not cause any damage to the basic structure of the Constitution of India on account of breach of the ceiling limit of 50% because that ceiling limit itself is not inflexible and in any case applies only to the reservations envisaged by Articles 15.4, 15.5 and 16.4 of the Constitution of India. Not much of the contentions have been urged in relation to the impact of the amendment in question on admissions to private unaided institutions. However, it could at once be clarified that what has been observed here and above in relation to the principal part of challenge to the amendment in question read with the decision of this court in Pramati Trust The answer to the issue framed in that regard would also be against the change. Accordingly, and in view of the above, the answers to the issues formulated in these matters are as follows. One, the 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions, including reservation, based on economic criteria. Two, the 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions in relation to the admission to private unaided institutions. Three, the 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution in excluding the SEBCs, OBCs, SCs, STs from the scope of EWS reservation. Consequently, the transferred cases, transfer petitions, writ petitions, and the petition for special leave appeal forming the part of this batch of matters are dismissed. Our acknowledgements while closing on this reference, sincere thanks and compliments deserve to be placed on record for the learned counsel for the respective parties, their associates and their researchers, and also all the constructive contributors whose erudite and scholarly presentation of respective viewpoints has rendered invaluable assistance to this court in shaping the formulations herein. Thank you.
I'll now invite Honorable Justice